Good morning. How's everyone doing?
Good morning, Judge.
Good morning.
I am here with my client in my office. So
Okay.
here.
Okay. When it's his turn to speak, do you just want her to turn the camera on him?
Well, what I'll do is I'll put it like this, so we're both here together.
Okay, perfect.
He's gonna have to sit closer to me. We
Okay.
can be like this for a while too, but yeah, he's right here.
Okay. All right. Miss Kirby, Mr. Kirby, good morning.
Good morning.
Rowan, good morning.
Good morning, Judge.
Good morning. And Blanca Espinosa isn't on this case, right?
Not that I know of, Judge.
Okay, let me check her in and see what she wants really quick. Let's see. Miss Espinosa? Maybe that was an accident. Put it back in the waiting room. Hold on 1 second. Someone just walked in the courtroom. Give me 1 minute. Okay. All right. And is everyone ready to proceed?
Yes.
Yes, Your Honor.
Okay.
Right away, this hearing sets the tone. It's streaming live on YouTube under the Texas Open Courts Act. That means transparency is front and center here. And trust me, when attorneys know the public is watching, every word suddenly matters a little more.
And for clarification purposes, this is streaming live on YouTube to be in compliance with the Texas Open Courts Act. And the courtroom doors are also open as well. Ms. Rowan. Ms. Rowan, this is your motion. Are you ready to begin?
I am, Judge.
Okay, are there any preliminary matters I need to take up before we get started?
I don't believe so, Judge. I intend to make a very brief opening statement since Your Honor already heard some argument from us last week or the week before. But I have no other preliminary matters.
Okay, and let me get the timer. All right. Okay, we are on the record in cause number DF 22-04493 on a motion for enforcement and clarification. Counsels, would you please state your name for the record?
Rebecca Rowan for the petitioner, Dr. Judith Kirby.
Lisa McKnight for respondent, Dr. Randall Kirby.
Okay, Attorney Rowan, you filed this motion. You may proceed with your opening statement.
Thank you, Judge. May it please the court. As you heard from us a couple of weeks ago, this is a petition for enforcement of property division as well as a request for clarification under Chapter 9 of the Texas Family Code. The parties had an agreed divorce decree entered by this court in November of 2022, ordering the husband, Dr. Randall Kirby, to timely pay all of the parties' 2021 personal tax liabilities. He's failed to do so, resulting in egregious interest and penalties that are accruing every month and are continuing to accrue. You're going to hear evidence today, Judge, that we have very real concerns about the respondent's burn rate and his spending habits. We do believe he has the funds to pay the remaining tax liability, because you'll see evidence that in September of last year, he received over $650,000 from the sale of the marital residence. But despite having the funds to pay the taxes, we are very concerned about his spending habits. So we are asking the court to enforce.
Okay, now this is where the numbers start getting serious. We're talking about over $650,000 from the sale of the marital home. But allegedly unpaid taxes are still stacking penalties every month. That's the kind of detail judges pay very close attention to because it shifts the case from a simple delay to a possible financial responsibility problem.
Your own decree and order him to pay this debt. We're asking you to clarify that word timely and order it to be paid by time and date certain. Specifically, we're asking for you to order him to pay it by next Friday, April 4th, 2023. The short time frame is in direct response to the evidence you're going to hear about our concerns about his spending habits. So that's the first thing we're asking you to do today, Judge. The second thing we're asking you to do is to order the respondent to execute a release, releasing my client from a business line of credit that in the divorce decree, he agreed to take that debt and indemnify my client. She's still on as a guarantor and a signer on that business line of credit. And we're asking him to simply sign a release that she can then provide to the bank to get her off of that line of credit. That's the second thing we're asking you to do today. The third thing that we're asking you to do is order attorney's fees to be paid by the respondent on behalf of my client because she had to file this lawsuit in the first place and bring it to the court's attention. And so you'll hear me testify in support of that request for attorney's fees. So it's very simple, Judge. And if I may share my screen.
Yes.
I've put together a summary of requested relief, and hopefully you can see it at this point, Judge. It's coming together. There it is. This is my summary of requested relief. It goes through the 3 things that we're asking you to do today, Judge. And so I provide this to the court for your consideration, and to the extent it helps the court, I've pre-marked it as P15, and I'm happy to offer it at this time.
Any objection?
Classic courtroom move right there. One attorney tries to introduce a summary exhibit during opening statements, and the other side instantly objects. Why? Because openings are supposed to preview evidence, not sneak evidence in early, tiny procedural moment. But these little battles often reveal how aggressive each side plans to be.
Attorney McKnight, you're muted.
I object insofar as we haven't started the hearing yet, and this is opening.
Okay, then I'll just wait. That's fine.
Okay,
Thank you, Judge. That's all I have for opening.
you're welcome. Attorney McKnight?
Yes, ma'am. I've looked at Ms. Rowan's requested relief today, and if she had started with that relief, that's some relief that we probably could have reached an agreement on. This is about a $5,000 enforcement case. That's it. And what she did was turn it into a nightmare requesting relief that she's not entitled to. It's interesting that the relief she's wanting today is nothing like the temporary order and injunctive relief that she wanted in the past month.
Did you catch that? What started as a claimed $5,000 enforcement dispute is suddenly being described as a nightmare involving sanctions, accusations of overreach, and nearly $20,000 in attorney's fees. This is where divorce enforcement hearings can spiral fast, because once lawyers start accusing each other of bad faith, the emotional temperature skyrockets.
And so attorney's fees is an issue. I have filed and set today also a motion for Rule 13 sanctions, both against Dr. Kirby and her lawyer for pursuing this action. And so there's some facts that are going to come out. Since the date of divorce, you'll learn that my client has paid well over $1 million in community debts. There is a practice loan that is in both of their names that he's responsible for, that he's made payments for every single month. And there's approximately $180,000 owed on it. What she wanted to do and what she asked, and what we've had 2 hearings set on already, is for him to have to put $400,000 into the registry of the court to cover the taxes that were owed, which were $175,000, and to cover this note, which is not due, for $180,000. What you're going to learn is that there has been 0 collection efforts on the part of the IRS or this practice loan. There was it's about $1.1 million in taxes that were due. He's paid all of them, except now that there's $175,000 that is due. After the divorce, he's remitted $200,000. It was $365,000 was due at the time the divorce decree was entered. Okay. Now, so what she came to court asking for was that he had to put $400,000 into the registry of the court to try to collect 2 unsecured debts. She's very focused on the proceeds of the house, which he was awarded. And really what's the most relevant factor here, Judge, is that we've had a hearing on this before. This was litigated. She filed a motion in the underlying divorce, had a hearing set in August on the issue of ordering the proceeds of the sale to be used to pay the IRS. That was a pleading. I have it. I'm going to ask the court to take judicial notice of it. It was set for a hearing and we reached an agreement that subsequently, and we proved it up on the record, that subsequently got entered in the final decree. That agreement awarded him the house unequivocally and ordered him to timely pay the taxes. Okay. Now, so
This phrase right here, a tempest in a teapot, that's attorney language for. The other side is massively overreacting, but here's the twist. Both sides are technically arguing the same core point. Yes, the taxes need to be paid. The real fight is over urgency, trust, and whether the court should force immediate action.
what we have, it's a tempest in a teapot. The man had owed a $1.1 million in taxes, and he now owes $175,000 in taxes. She's repeatedly said, and it's factually incorrect, that there's $17,000 of penalties and interest accruing a month. That is not true. There is no document that she has that will demonstrate that. He will pay 100% of the taxes. Today is the first day I got this purported release that she wanted signed, which he signed it already. If she had sent me this in the beginning of the lawsuit, I would have happily signed the release. Okay, that's not what she wanted. She wanted to accelerate the $180,000 note, cram it down his throat, make him pay it off with the proceeds of the house, which she's not entitled to do. And now she's finally abandoned that claim. She's, after we've had 2 hearings on this already, after we had to brief it to the court. And so what should be a $5,000 enforcement case, 1 motion, 1 hearing, is now a $19,000 enforcement case in a Rule 13 sanctions. And so that's the issue, is who's paying whose attorney's fees at the end of the day here. What's transpired is a travesty. She knows, or should have known, that's not appropriate relief to ask for. So the relief that we're having today is extremely watered down. It's basically, and I don't disagree. So what she wants is for you to clarify when he has to pay the taxes, okay, and clarify the amount. That's going to be real easy. The amount's $175,000, and so you're going to either decide when does he have to pay that. Our proposal is that the court set a report back in 90 days from today's date to see if he's complied with payment in full of the IRS taxes. Okay, the man has been paying taxes for all his life. He's never not paid the IRS. The relief she's wanting with respect to the other note, now it's just have him sign a release. Okay, done. We signed a release. It's basically the decree already released her from this, but that's not really what she wanted. What she wanted was you to force him to pay the whole note off. That's what she wanted. And that's why she wanted you to order him to put $400,000 into the registry of the court and not be able to spend any money on anything else until he paid that note and the IRS. That is so egregious as to rise to the level of Rule 13 sanctions. And that is also set before the court today. And those are the issues.
Thank you.
Now the petitioner's attorney fires back hard. This is no longer just about unpaid taxes, it's becoming a credibility battle between lawyers. Notice how she carefully separates the temporary emergency requests from the final trial requests. That's strategic lawyering. She's trying to show the judge, I've been consistent from day one.
Judge, may I briefly respond since I'm the petitioner?
Sure.
Thank you. First of all, I object. I did not see a notice of hearing for the motion for sanctions being set for today. Ms. McKnight, if I'm incorrect and it's out there, please point it out to me and I'll certainly look for it. But I'll cite my objection to that going forward if it's not properly set. I take serious issue, Judge, with this allegation that I have somehow abandoned certain requests, that I have somehow watered down certain requests. Judge, I beg you, go look at my petition for enforcement that I filed in January on this case. I asked for at final trial, which is where we are, this is final trial, I asked for him to sign a release to enforce the tax debt and order it to be paid by a time and date certain. Those are the same requests I pled for, and I'm asking you to do it today. Now, completely separate and apart from that, I had a request for temporary orders and temporary injunctions. That was set before Judge Lee. We presented arguments on it. She indicated to us that she thought both sides had merit to the argument. And then we presented some of those arguments to you a couple of weeks ago. That is a completely separate and different issue. That is a temporary orders request. So if somehow Ms. McKnight is trying to put those together and say, I'm abandoning claims and I'm watering down claims, that's not true. Those were my temporary orders requests. Today, we're set for final trial. So this is what I'm asking you to do. I find it really interesting that for the first time I'm hearing, we probably could have agreed to this. This was in my petition from day one, from January. If we could have agreed to these things that I'm asking you to do today, it certainly would have been helpful to hear that back in January and February when I first filed this petition and Ms. McKnight had a copy of it. So to the extent she's now saying, oh, all my requests today are so reasonable and she would have agreed to it, then what are we doing here? Why couldn't we have settled that if she would have come forward to me and told me that? But be that as it may, I just wanted to clarify those particular points. I also take issue with the fact that Ms. McKnight is telling you what I was requesting and why I was requesting it. In my initial petition, I requested $400,000 to be put into the registry of the court because that was the total tax debt owing at that time. And then subsequent to my filing the petition, the respondent paid a $200,000 payment to the IRS. So it went from a $400,000 approximate tax debt number to about $175,000. And that's the number I'm requesting today. I was never asking you to put $400,000 into the registry of the court to be both the line of credit money and the tax debt. I was concentrating on the tax debt because that's the thing that's accruing interest and penalties. So I just wanted to clarify that for the court. I think that was everything that I wanted to say, Judge, and I'm happy to call my first witness.
And there it is, the sanctions issue officially enters the chat. In legal terms, Rule 13 sanctions are serious business because they basically accuse the other side of filing claims that are frivolous or improper. Judges don't hand those out casually, so whenever sanctions are mentioned, everybody in the courtroom suddenly gets a lot more careful.
Okay, thank you. You may proceed.
Thank you.
And Judge, on the issue of notice with respect to my sanctions, Ms. Rowan, I have proof of service where you opened it on 3/24.
Okay, I'll go look at my emails.
Okay.
Attorney McKnight, I was just getting ready to mention that. Ms. Rowan, it is on file with the court. It was filed March 24th at 4:46 p.m.
Okay, thank you. Appreciate that, Judge.
You're welcome. You're welcome.
And I'll call the petitioner, Dr. Judith Kirby.
Okay, let me swear in both parties. Would you both, Ms. Kirby, Mr. Kirby, would you both raise your right hand? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
I do. Okay, say it again with the microphone.
Yes, ma'am.
Thank you. You may lower your hands, and Attorney Rowan, you may proceed.
Thank you. Will you please state your name, ma'am?
Judith Kirby,
And where do you reside?
Dallas, Texas.
What do you do for a living?
I'm an eye surgeon and ophthalmologist.
Do you own your own medical practice?
Yes, ma'am.
And are you the petitioner in this case?
Yes, ma'am.
Judge, permission to share my screen?
Yes. And both attorneys, you can share your screen as necessary. You don't have to ask.
Okay, thank you, Judge.
You're welcome.
Dr. Kirby, can you see the summary of requested relief in front of you?
Yes, ma'am.
And does this accurately summarize what you're asking the court to do today?
Yes, ma'am.
I'll offer P15.
Any objection?
No objection.
All right. Petitioner's 15 is admitted.
Thank you. Dr. Kirby, can you see petitioner's exhibit 1 in front of you now?
Yes, ma'am.
And is this a true and correct copy of the agreed final decree of divorce relating to your marriage to Dr. Randall Kirby?
Yes, ma'am. Yes,
I'll
ma'am.
offer P1.
Any
No
objection? All right. P1 is admitted.
Dr. Kirby, I'm going to direct your attention to page 10. And on page 10, is there a section entitled liability for federal income taxes for prior year?
Yes, ma'am.
And I'm going to highlight a section and read it. Let me know if I read it correctly. It is ordered and decreed that Randall Parker Kirby shall be solely responsible for all federal income tax liabilities of the parties allocable to December 31st, 2021, as reflected in the 2021-1040 joint tax return, and shall timely pay any taxes, penalties, and interest due thereon, and shall indemnify and hold you and your property harmless therefrom. Did I read that portion of the sentence correctly?
Yes, ma'am.
And so
This testimony is quietly establishing something very important, earning power. Both parties are highly successful surgeons, and the court is hearing evidence that the respondent was allegedly making around $3 million a year. Why does that matter? Because inability to pay becomes a much harder argument when income at that level is on the table.
based on your understanding, who was supposed to pay the parties' federal income tax liabilities for 2021?
Randall Kirby.
And what date did you all get divorced?
The technical date was August 23rd, 2022, and it was signed by the judge on November 1st, 2022.
What does your ex-husband do for a living?
He's a vascular and general surgeon.
And does he own his own medical practice?
Yes, ma'am.
And to the best of your knowledge and recollection, approximately how much income does he bring in each year?
As of through December of 2022, he was bringing in anywhere from about $3 million a year on average.
Okay. I'm going to show you, ma'am, what I've pre-marked as Petitioner's Exhibit 4. Can you see that on your screen?
Yes, ma'am.
And is Petitioner's Exhibit 4 a true and correct copy of you and the respondent's 2021 federal income tax return? And I'll
Yes.
kind of scroll through it so you can see it.
Yes, ma'am.
I'll offer P4.
Objection.
Unless are my clients' social security numbers redacted?
I think this is the redacted version. Yeah, it is.
Okay, I have no objection as redacted.
All right. P4 is admitted.
And on P4, Dr. Kirby, can you see here on the form 8879, how much does the 2021 tax return reflect that you and Dr. Kirby owed? Sorry, I highlighted too much there.
No, I can't see because the pictures are on the side of the computer.
See if you can drag the picture over a little bit, maybe, or I'll have Amy come in there and help.
Oh, there you go. Okay, yes, I have it. Yes, ma'am.
Okay.
Okay.
And so how
I'm
much
sorry,
does that text, does P4 reflect that you all owed for 2021?
And finally, we arrive at the centerpiece of the dispute, the actual tax debt amount, nearly $344,000 owed for 2021 alone. Cases like this remind people that high-income divorces aren't just emotional, they're financial chess matches with IRS consequences attached. One delayed payment can snowball into enormous penalties.
As of the end of December 31st, 2021, the tax owed was $343,732.
Thank you.